Hi everyone, it's Carolyn from True Crime Chat with Mommy Ramblings. I was looking on the judicial site where everything, for Colorado, where everything for Letecia, all the motions, the affidavit, everything gets posted there that's released. And I found something that was interesting to me, that she had requested a sanctions hearing. And I'll tell you why she did that, but I'll actually show you exactly what was requested. And it was because she said someone was talking about what happened in Kansas with the deputy, and then also how Gannon was found and about the suitcase. And the judge denied it. Now, her actual request was not on the site, and I think that's because they didn't want to release that yet. Maybe there's information in there they do not want to release to the public at this time. That's what I'm thinking. But the judge referenced it in his denial, and that's what I want to show you here. Okay, so let's take a look at this. And if you're new to the channel, there's the subscribe button on the bottom of the video. I'd love it for you to subscribe and join one of the best communities on YouTube. And then you can also click the notifications bell so that you're notified every time we upload a new video or we go live, which we do most every evening. We're a lot more than true crime here. You'll find a full variety of things. We're kind of like a digital magazine with a strong emphasis on true crime. But let's see what's going on in here. So this, I just want to show you, is a portion of what's on that site. And this is just, so if you're not familiar with this, this is what's posted. You could see there were motions to amend complaints and information, reschedule status conference. She did have another motion up there where she wanted to, and I will show you that as well, wanted to put on hold, excuse me, not put on hold. She wanted to not put on hold that her status conference. And she basically is saying that, even though all the virus stuff, she would like that still to go forward. And, you can look at it here, but what I'm going to show you is what I find most interesting right now. Let's take a look at that. So this is the top of the judge's denial. So this is order denying request for hearing for sanctions. Okay, so this is what I found interesting. Now, even though Letecia's motion for a request for a hearing for sanctions is not up on the site, the order denying the request for the hearing for sanctions is, and the judge references what Letecia put in her motion. So let's take a look, okay, at this. So it says, this matter comes before the court pursuant to Ms. Stauch's motion for hearing on sanctions for a violation of a court order. What that means is that this is going to address Letecia's motion that she put in there for a hearing on sanctions for violation of a court order. So she's saying someone violated a court order and she wants a hearing on sanctions because of that. So what does she think they violated? Let's find out. According to paragraph 2 of the motion, Ms. Stauch requests an investigation into a statement made by an individual regarding an alleged crime committed by Ms. Stauch in Kansas. This court has no jurisdiction over that crime. What does that mean? It means that, well, what do we know happened in Kansas when they were transporting Letecia from South Carolina to Colorado? She slipped out of cuffs and she attacked a deputy. That deputy had to go to the hospital, okay? Letecia was kept there overnight. The judge already addressed in the last hearing that that is in the jurisdiction of the Kansas courts, okay? He's doing that again here. He's not even going to talk about this individual because he's saying this court has no jurisdiction over that crime. Okay, so she's saying there's an individual that's made a statement. Okay, so someone's talking about what she did in Kansas. Judge says this court has no jurisdiction over that crime. The second part of this, according to paragraph 4 of the motion, Ms. Stauch references a source as reporting that Gannon Stauch's body was found in a suitcase under an overpass. So now she's saying this is a source, not an individual, and they are reporting that Gannon's body was found in a suitcase under an overpass. Counsel then asserts in a conclusory fashion that the source of this information had to be one of the listed agencies or parties prohibited from discussing the case pursuant to O-1. Significantly, there is not yet any evidence in the record regarding the cause of death for Gannon Stauch or how his body was found. As such, it is not even clear whether the facts related are accurate, whether they were made by someone with first-hand information, or even law enforcement at all. So let's look at that part of it, okay, before we go any further. She's saying it's a source. She's saying that they reported Gannon was found in a suitcase under an overpass. Okay, well, the judge is saying, hold on here for a second, right? Hold on, because Letecia says the source had to be one of the listed agencies or parties that's prohibited from discussing the case. So the judge says, wait a minute, there isn't even any evidence in the record regarding the cause of death for Gannon Stauch or how his body was found. And so he then goes on to say, it's not even clear whether this statement that Gannon was found in a suitcase under an overpass is even accurate. And furthermore, whether it was made by someone with first-hand knowledge or even law enforcement at all. So they don't even, he's saying, there's nothing in the record. We don't even know if it's accurate. And we don't even know who made that statement, who was speaking about that, how Gannon was found. Was it someone that had first-hand information? And by that, it could mean anyone that was in the area at that time that saw what happened, a road crew worker, it could be anyone. It could be a family member that had knowledge of that, or law enforcement, anyone on law enforcement that was there, right? So he's saying we don't even know where this even came from, if indeed it came from, and if indeed it is even true. Now, there had to be reference to a news story, because his next part of this says the news story reference in the motion starts out by stating that the details were first reported in a newspaper overseas. The motion does not identify what newspaper that would have been or the substance of that story. Now, obviously, she's talking about the Daily Mail, okay, which is overseas in the UK. Daily Mail stories are usually, like in this kind of case, true crime from the United States, they usually have an inside source or a source close to the investigation is what they say, or something like that. And like I said, the Daily Mail is not known for truth in reporting, though they do have a lot of accurate reporting there. They like to sensationalize things, in my opinion. And so apparently Letecia and counsel did not give them the name of the publication. So that is what the judge is saying there. The motion does not identify what newspaper that would have been or the substance of the story. There is also no indication in the motion regarding when law enforcement in Florida learned that the body found was that of Gannon Stauch, or when Florida law enforcement authorities would have become aware of this court's order. So now what he's saying there is nothing in the motion told about when law enforcement in Florida learned that the body found was that of Gannon Stauch. Now, we know that it was found, and then El Paso was contacted a day later, right? The next day. So when the body was found, what the judge is trying to say, how could they violate any order when there was no order at that time, when they didn't even know the identity of the child found, right? So if somebody spoke at that time, before that time, so how could we say when they spoke, right? And the court order wasn't even there. Florida law enforcement authorities were not even aware because it didn't exist, that court order. The court simply declines to take further action at this time based on the conclusory and speculative arguments of defense counsel. So he's saying, look, this is just, you're coming to all these conclusions, you have all this speculation, and we know, isn't it Letecia the one that's saying the case is 90% speculation? Well, you know, I can't even believe her counsel even submitted this, because it's just, well, that's why defense lawyers get such a bad name, I guess. This is just nothing but conclusions, speculations, and anything to create some kind of diversion from all of this evidence that is there and implicating that Letecia did this horrific act to this child. Okay, so let's go over what the judge said again there, okay? The court simply declines, we're not doing it, to take further action based on the conclusory and speculative arguments of defense counsel. If counsel has further facts to share in the form of an affidavit regarding such, the court may reconsider the matter once such facts are produced. So if you want to go back and get us facts, remember facts are important, instead of just coming up with conclusions and speculation about something, we'll take another look at it. Okay, maybe we'll reconsider if we see that. At paragraph 7 of Ms. Stauch's motion, defense counsel alleges that through investigation, the defense has learned that the original affidavit listed in the e-filing system was replaced with the redacted version of the affidavit. The redacted version of the affidavit was not sealed and instead was accessible to the public. Okay, so now she's saying this is when the affidavit was available on the site earlier than was anticipated, but it was a redacted version. And so she's going to take this up now. So we're just going to go again. Counsel fails to set forth any specific facts in an affidavit. Give us the facts. We don't want speculation. Let's go on. That were revealed through counsel's investigation. This is important as the court issued order O-06 unsealing the affidavit at 11:20 a.m. on April 3rd, 2020. Any changes regarding the replacement or unsealing of the affidavit of probable cause after that point in time would have occurred as a result of this court's order. Okay, so again, we need facts. What are you guys talking about? When did it occur? If it occurred after 11:20 a.m. on April 3rd, okay, any changes regarding the replacement or unsealing of the affidavit after that point in time would have occurred as a result of this court's order. Defendant did not file any supporting affidavits setting forth any specific facts regarding conduct attributable to the district attorney's office or any other parties that are subject of the O-1 order. Defense counsel is free to continue its investigation, but based on this meager record, the court declines to take further action at this time. As such, Defendant Stauch's motion for hearing on sanctions for violation of court order is denied. So ordered this 14th day of April 2020 by the court, Gregory R. Warner District Court Judge. So it's denied. It's not happening. Bye-bye now. You know, that's it. It's not going to happen. Sorry. Okay, now since it's being referenced in the motion and what Letecia is claiming was violated, we're going to look at the O-1, pretrial publicity. The court anticipates this case may receive some attention from the media and has already done so. The case is likely to continue to generate media attention. In order to protect the rights of all parties to a fair trial by an impartial jury, as guaranteed by the Colorado and United States constitutions and consistent with Rule 3.6 of the Colorado Rules of Professional Conduct, the court enters the following order regarding pretrial publicity. 1. The order shall apply to all parties, attorneys of record, any attorney associated with an attorney of record, employees of the district attorney's office, employees of any party or attorney of record, investigators working on behalf of any party or attorney of record, and all public law enforcement agencies involved in the investigation of this case. No person identified in paragraph 1 of this order shall make any extrajudicial statement regarding any aspect of the case except as follows. Information contained in a public record, including information contained in court documents which have not been filed under seal. Information disclosed during court proceedings unless such proceedings are closed by court order. The fact that an investigation is in progress and a request for information or assistance in connection with that investigation. The dates of any scheduled court appearances and the general nature of the matters to be addressed at those hearings unless such proceedings are closed by court order. Identifying information regarding the accused. The fact, time, and place of arrest and the identity of investigating and or arresting officers and the agency with which they are associated. Before we go on to the rest of this, let's just look at that. So here's who the order applies to. The order applies to the attorneys and any attorneys associated with them. It applies to all the employees of the district attorney's office and the employees of any party or attorney of record. It applies to the investigators that are working on behalf of any party or attorney of record and all public law enforcement agencies involved in the investigation of this case. Does this involve her neighbor? Is Roderick bound by this? No. Is her cousin twice removed in California? Not that she even has one. I'm just trying to make an example here. Is that if she did have a cousin twice removed in California, would this pertain to them? No. Do you see them listed there? No. Okay. So let's, and then they are not to speak about certain things. They can't make extrajudicial statements regarding any aspect of the case except if it's information that's in a public record, including information contained in court documents that have not been filed under seal. Information disclosed during court proceedings they can speak about, unless such proceedings are closed. The fact that an investigation is in progress, and a request for information or assistance, so they can say, yes, an investigation is in progress, we could really use help, just like they did. If anyone saw Letecia in the Pace, Pensacola area on these dates, please contact us, right? They can talk about that. They can talk about the arrest affidavit. They can talk about anything that's been released, and they can talk about public records, even if they have not been filed under seal, okay? Then we go on. They can talk about the dates of future court appearances, the general nature of the matters that are going to happen there. They can talk about the fact, time, and place of the arrest. They can talk about identifying information regarding the accused, and they can talk about the identity of the investigation and or arresting officers and the agency with which they are associated. Okay? Okay, so we're just going to continue from there. They can talk about a change of venue for violations of the terms of this order. The order shall remain in effect until further order of this court, so ordered this 5th day of March, 2020, by the court, Gregory R. Werner. Okay, and that is that. So that's what she is saying there was a violation of. Now, if you go back and listen to the beginning, if you had any questions about what they were talking about, this is it. Okay. The site, you can go on the site, the judicial site for Colorado, and pull this information up. I'll try to put a link in the video description so you can pull that up and you can go through the other motions and stuff. But this is very interesting to me because it seems like there's a lot of straws that are being grasped at, which just has me thinking Letecia again is thinking, wait a minute, you know, I'm going to take something and let me make a mountain from it and deflect and start putting all of this that somebody violated this and somebody violated this, so it takes all the attention off what I did, what she's allegedly did, right? And maybe it'll be, you know, like I imagine too, maybe she's looking at a case that some type of technicality or, you know, something caused it to be dismissed or whatever, or really tainted the whole case, and she's thinking, you know, let me see what I can do to do something like that here, you know, to make something like that occur here. I think she's freaking that, and also that she is really upset that she needs to remain in jail until June, because I really think that she thinks that she could possibly be released on bond. You know, and that's this holding her up. It's just, it baffles me. She came out with that statement before saying that it's 90% speculation. You know, I mean, the girl is really a very, very mentally ill person. So, all right. I just wanted to bring that to you. I thought it was interesting, and I think a lot of you think like me and probably found that a little interesting to see that. Kind of gives you a little glimpse into what she must be thinking. Anyway, we can discuss it later on tonight. I'll be on in a little bit live. So thanks so much for watching. I hope you're all having a great Friday. Bye-bye.